Well, because I knew Michael was going to say it was a splendid paper, I really wanted him to go first. After I read, Michael was kind enough to give me an advance copy of his reaction, and after I read them, I realized most of what I wanted to say would be in response to his response, and so why take up 10 minutes just summarizing a paper that all of you have read, and which Michael implicitly summarizes in the course of his comments anyway. I could just devote my time to talking about what he has to say, some of the very interesting things he has to say, including things that I, much to his surprise, I think, agree with. So let me first begin by telling you where this project started and why I'm doing it. It's part of a larger work on the original meaning, well, it was part of a larger work on fundamental rights in the Constitution, and it was part of the subpart of the book which talks about the original meaning of the 14th Amendment, the original meaning of Section 1. So I started off with the principal objective of trying to establish what the original meaning of Section 1 was, and I had a secondary objective of learning about myself and reviving the memory of the abolitionist constitutionalists, which I knew very little about, except for as some of you know, I have quite a lot of familiarity with Lysander Spooner's work, and Michael has been telling me to read Tiffany forever. So that was pretty much it. So I started this work over a year ago, and immediately, I mean within weeks of starting the reading, I realized that it wasn't going to tell me nearly as much about the original public meaning of the 14th Amendment as I hoped it would, for the obvious reason, it seemed obvious then, it didn't seem obvious when I started, that these folks are all writing lawyerly arguments about the Constitution as it existed at the time they were writing. These were serious constitutional arguments being made about a Constitution that did not have an Equal Protection Clause, therefore what they have to say is only somewhat related to the one we have, did not have a citizenship clause, and had a privileges or immunities clause that's quite different in its wording from the one that's in Section 1, and a due process clause that's very close, but still not exactly the same. And so it shouldn't have been a surprise, but I found out right away that reading them was only going to give me some idea, some background context to what the public meaning of Section 1 was. I nevertheless persevered for a year working through these sources because I found them inherently interesting, and my secondary objective for writing this paper became my primary objective, which was to revive the memory of these people who, notwithstanding Michael's efforts, has been lost to American constitutional lawyers and law professors, and so that is my primary objective. I think it has a secondary. It's going to be of use secondarily to, for example, address claims that Kirk makes and other people make about what must be the public meaning of these things, but only when combined with other evidence, not by itself. So let me just talk a little bit about the first part, the snuffed out thesis, which is the new introduction to the paper, the introduction that currently exists. I don't want to make too much of this, but I'm making a cultural claim here. The cultural claim here is that constitutional law professors don't know about the abolitionist constitutionalists, except what they've been told, but, to the extent they know anything about them at all, except what they've been told by Bill Nelson or Bob Cover. Now I realize, and I am a big fan of Michael's work, and Michael, you know, has been huge. His work, No State Shall Abridge, has been hugely influential to me and many, many other people. But I submit it has been hugely influential for reasons other than the fact that it revived interest in Joel Tiffany. Much as I'm sure he wishes his book had been famous for that, I believe it's famous and cited for other matters, not for that. And in fact, I don't think, as a cultural matter, Michael or Richard Ains, for example, who deserves a tremendous amount of credit for doing his own work in this field, have successfully raised the consciousness of American law professors about the existence of these folks, for one thing, and the coherence and care with which they argued. American constitutional law professors are still left with Nelson's judgment, adverse judgment, and with Cover's even more harsh adverse judgment. And I have to say, I really, really like Bob Cover's book a lot for many, many things, but just not for this thing. And I think that, you know, dumping on these guys as constitutional utopians whose work has little, if any, importance at all, I think took. And I hear this kind of reference all the time to Lysander Spooner, and that's somebody people know enough to dump on. They don't even know enough to dump on Tiffany and these other folks. So anyway, so that's my principal objective. So now let me now turn to where it is. So that's Michael's first disagreement about the snuffing out thesis. So I hope he's right, actually. I hope this is speaking to the choir. Everyone already knows about these folks, but I suspect that's not true. And if this article is prominently placed, more people will know about them now than they used to know about them. I also think they were very serious thinkers, very serious lawyers, making serious arguments. And it was my intention to convey these as serious constitutional arguments. I believe stronger arguments, comparatively speaking, than the arguments presented by Justice Story and Prigg or Justice Taney and Dred Scott. These are better constitutional arguments, right? Now, the public meaning quote. Now, this is where I think Michael might be surprised. Michael said in his comment, even really more elaborately in the written version of it than he said to you, that he doesn't really think that these folks are doing public meaning originalism because public meaning originalism must take into account the context of the words used. And in this, I just want to say I agree with him. And it's for this reason that I've never, until there may be a hint of that in this paper, but I have never up until this point, as long as I've been writing about Lysander Spooner, said that Spooner's public meaning argument works. I've never claimed that Spooner was right about the Constitution being an anti-slavery document in the sense that he meant it, even though his writing on public meaning greatly influenced me. And so I want to say to Michael that I'm right. I agree with you that the context is relevant to the semantic meaning of the words as uttered when they're uttered, and that will include considering extrinsic evidence of the kind that some of these folks, including Spooner, wanted to shut out. And they wanted to shut it out in part because they wanted to succeed in the argument they were making. But having said that, let me also suggest that I think that that it's only been very, very recently, it's only since this article that I wrote in the Northwestern Law Review called The Misconceived Assumptions about Constitutional Assumptions, that I came to realize that there's a reason. I kept going back and forth about Spooner. Spooner's the one that's making the public meaning argument. Then the other ones picked it up after that and really continue to run with it. But there's something I keep going back and forth on that with them. You say, yes, it's not right because of this context point, and of course context matters, and of course people knew persons was a reference to slaves here, and persons was a reference to, yeah, we know that. Yeah, that's right. But on the other hand, they had this word slavery. Slavery would actually have described what they meant to talk about, what they allegedly are talking about, what we think they're. But they don't use the word that would actually. They don't use that word. What word do they use? They use the word person. In other words, they speak euphemistically, and they do so on purpose. Now, it's now starting to dawn on me, not because I disagree with anything you've just said, but this might actually be a weird linguistic special case problem that's quite special. And now when you have framers of a document choosing to use euphemisms to describe something, you introduce an ambiguity into the document on purpose that creates special problems of interpretation and construction that don't normally exist for originalism, because people aren't speaking euphemistically usually. And what does it mean to speak euphemistically? It means you take a word that is perfectly innocent of this other meaning. It's really unrelated to the other meaning. Person and slave, I mean, we use them in completely different ways. And you take this innocent word and you use that as reference to this illicit concept. And you do it on purpose. Now, what's the effect of that on the reader? The reader's going to see an innocent word, and there's going to be this contextual reason why we think that was a reference to this, maybe good reason. But maybe in some parts of the country, as Spooner argued, that some people would rather have burned the Constitution at the hand of a common hangman than to have agreed to something that had the word slavery in it. If Spooner's right about that there are parts of the country that felt that way, then that use of euphemism was done for a reason, and it was done to avoid responsibility or to avoid putting into the document this bad meaning. So this problem of euphemism, which is very rare, but obviously it exists here, creates a problem, I think, not so much of whether context is necessary to establish original meaning, but whether even once you've gone through the whole context, you find an ambiguity, perhaps an irreducible ambiguity, that then must be resolved by constitutional construction, because you rarely have a choice between it means this or it means that, and then how do you resolve the ambiguity? Most of, at least a goodly part of Spooner's argument and the argument of the others, is that at that point you adopt a clear statement rule with respect to resolving ambiguity, and that is you do not assume that it has this terribly unjust meaning unless it's a perfectly clear statement. He borrows this clear statement rule from Chief Justice Marshall's statement of a clear statement rule in statutory construction from U.S. v. Fisher. He takes that And you can actually trace Spooner's influence on other abolitionists from their citation of U.S. v. Fisher. And he takes this clear statement rule to figure out which of two meanings do you pick when it could be one or the other. This is not a rule of interpretation. This is a rule of construction. It was put forward as that. And I think at that point, that's always doing a lot of work in Spooner's work and in his reasoning. So I think this special problem of ambiguity created by the use of euphemism is creating this conflict in us. But it's not but I agree with Michael about the use of context to establish meaning. Finally, just a few points he makes. I've still got 4. Okay, finally, a few points he makes about Bingham. I think that, Mike, there's some point we've misunderstood each other. We didn't have a chance to talk to get to. I do not believe in any way, shape, or form that Bingham thought that the 14th Amendment was not enforceable by Congress, that it was only enforceable by courts. It is interesting, I think, that these abolitionists thought that Article 4, some of the abolitionists thought that Article 4 did not empower Congress to make any laws, but was something that would cause a court to make a ruling. So a court could enforce the treaty that Article 4 is a treaty provision amongst the various states that is not something that gives Congress the power to authorize any law. But when those treaty provisions are implicated in a lawsuit, it's possible for a federal court to follow the treaty. For example, if Pennsylvania claims that a slave has been freed as a result of having escaped into it, a court could say, no, under Article 4, the runaway slave law clause, that ordinarily you'd be right, because ordinarily, since slavery is a local matter of positive law, if you get to the place where there is no slavery, you are free. But under this terms of a compact, the Constitution says that's not going to work here. You have to return the slave. So Article 4 might be enforceable in court where it's not enforceable by Congress. And that's all I meant, I think, by Bingham's early use. Not that Section 1 isn't enforceable by Congress, because we have Section 5, which specifically authorizes congressional enforcement. All right, and finally, Michael would like to have more info on privileges or immunities from these guys. So would I. There was a lot less there than I hoped there would be. I've given you pretty much everything that's there. I mean, not every word, but everything that I thought was worthy of reporting is in there. And one of the things that curiously is not in there, and I have no real explanation for it, Corfield versus Corio. I never found a single mention of Corfield versus Corio by these folks. You would seem it would really be helpful to them if they knew about it and used it, but they didn't. And I have no there is no all I have is speculation about why, but here's my first hypothesis about why that might not be, and that is I think a lot of these things have to do with culture. And if a particular, like Spooner found U.S. v. Fisher, and then after that U.S. v. Fisher gets cited all over the place. If Spooner hadn't found U.S. v. Fisher, I doubt U.S. v. Fisher would have been something the abolitionists had repeated over and over again, but nobody happened across Corfield. And because they didn't happen across it, they never used it, and it didn't get from one person to another, and so it really wasn't part of their discourse. Not that I think that they wouldn't have loved to have it if they'd have thought of it, but they just didn't think of it. But that's the only thing I can explain why they never even – it's not mentioned one way or the other, as are other things that aren't mentioned one way or the other. Anyway, I just want to end with saying that what did you call it, a splendid paper?
Yes.
I agree with Michael 100%.